Madam, I beg to move that the total sum to be allocated for Head B of the estimates be reduced by $100. Madam, AGC's establishment headcount this year will be at an all-time high of 594, which compared to the actual headcount 7 years ago is a 42% jump. It would be enlightening to know why so many more officers are needed, where these additional headcounts have been allocated, and whether this trend will continue and why. Next, the mission statement of the AGC reads as follows: serving Singapore's interests and upholding the rule of law through sound advice, effective representation, fair and independent prosecution, and accessible legislation. There are two further observations I wish to make. First, we see senior AGC officers recruited from the private sector, such as from large law firms. I agree that AGC can benefit from private sector talent who inject fresh perspectives and updated market knowledge. However, do such persons receive any briefings to reorientate their mindsets to function as public officers rather than private sector lawyers, from serving a client to serving the public? A private sector lawyer may be briefed to go all out to protect his client's interests, but an AGC officer should not simply go all out to ensure that the government wins in court, but should serve Singapore's interests by promoting justice. It is common these days to see AGC officers refer to government bodies in court as their client, in correspondence as well. This to me is disturbing. Secondly, the AGC as an organ of state should be independent and ready to rein in the government if it acts unlawfully or is abusing its power. To this end, I am most concerned about the recent appointment of a former MP as the Deputy AG. This is not a personal attack against the new Deputy AG, nor on his legal competence, but it is my view that filling a constitutional post in an organ of state with a party politician is not ideal, as it carries a risk of undermining public confidence in the AGC's stated mission of fair and independent prosecutions, and it is a risk that is best avoided.
The question is that the total sum to be allocated for Head B of the estimates be reduced by $100. SMS Indrani Raja.
Madam Chairman, Ms. Lim asked about the increased AGC headcount. Looking at the period from 2011, then AG, Mr. Sundaresh Menon, felt that the AGC was understaffed. His successor, Mr. V.K. Raja, took the same view as well. AGC raised it with MOF. MOF has also done a manpower review. AGC's headcount was increased. Much of the recruitment thus took place from 2011 to 2015, with a 35% increase in headcount over that period. This helped to right-size the AGC and ensured that it could deliver quality legal services as required by the public sector. The increase in manpower allocation was necessary in view of the fact that AGC's portfolio and work demands have increased significantly over the past few years. For example, the AGC has taken on an increased volume and complexity of civil and criminal hearings. In recent years, there has been a significant increase in the complexity of white-collar crime cases. There's also been an increase in sophisticated, organized, and internationalized criminal activity. The complexity of legal advisory work has also grown in tandem with the increasing multifaceted nature of the government's work. The demand for legal input to improve and speed up the formulation and implementation of policies has also increased. In the international arena, the AGC has managed an increasing number of disputes and negotiations to advance Singapore's interests. The AGC has also taken on several new functions. AGC now provides legal representation for statutory boards in judicial review proceedings. AGC has taken over prosecution work from the Police Prosecution Branch. The AGC legislative team has embarked on the Plain Laws Understandable by Singaporeans, or PLUS project, an initiative to improve and modernize legislative drafting to make our laws more accessible to the public. With AGC's improved manpower situation, we do not expect the same pace of manpower growth to continue into the foreseeable future. Ms. Lim also asked about mid-career recruits to the AGC. The mid-career changes are common in many industries. The legal industry is no exception. Mid-career hires can bring along fresh perspectives and ideas honed by their experiences elsewhere. The key considerations are whether the mid-career hires possess the necessary skills, aptitude, and desire to serve the public interest. We do not see any basis for suggesting that mid-career entrants will not serve the public interest. It will be noted that many of our judges are appointed to the bench from the private sector. Can it be suggested that they are all not suitable because they come from the private sector? It will also be noted that some cabinet ministers are appointed from the private sector, including both office holders in the law ministry. Would Ms. Lim suggest that they are not suitable because they were not in the public sector all their lives? Finally, Ms. Lim seems to suggest that senior officers in the AGC should not have had any political affiliation. If she's saying that, as a matter of institutional philosophy, that there is something inherent about the office of AG that rules out political affiliation at some time, then that will be inaccurate. In many first world countries, the AG, as head of the AGC, is in fact a sitting MP or politician. In the UK, the AG is a cabinet minister. He is also the chief legal advisor and also oversees the prosecution service. Australia has a similar system. The AG is a member of the legislature. Likewise, in the United States. In the US, the president appoints an AG, and the current AG was a Republican senator, no less. The US AG has taken positions on political issues as a senator. He resigned from the Senate just before being appointed AG and continues to be a member of the Republican Party. So as a matter of systems design, many countries see it perfectly proper to have an AG who is a politician. We have adopted a slightly different model. In our system, the AG and AGC officers are not politicians and are not members of political parties. But it is going too far to suggest that AGC officers must not have previously had any links with any political party. We must bear in mind 2 points. First, the AGC must be led by the best legal talent available. Our talent pool for the highest legal appointments is small. It is common for political parties to get the best legal talent. Some of our top lawyers have been MPs. Look at the senior partners and top lawyers in our largest firms. Drew Napier, Mr. Devinder Singh, SC, who is generally recognized as the top litigator in town, was a PAP MP. Wong Partnership, the top litigator, Mr. Alvin Yeo, SC, was a PAP MP. Ellen and Gledhill, one of the 2 SCs in the litigation department, Mr. Edwin Tong, is a sitting MP. Madam, may I beg your indulgence? I just have a few paragraphs more.
Yes, please proceed.
Thank you. If you look at Raja and Tan, the current CJ, as well as Justice of Appeal Stephen Chong and Justice Quentin Low, came into public service, as well as the previous AG. And in the last few years, several others who have also been taken from other firms and the private sector to come to public service. In our view, those whom I mentioned who are still in private practice would all, together with Mr. Hari Kumar SC, be considered to be among the top 6 to 7 litigators in town. This wealth of talent should be available to the public service. Ultimately, the most important considerations are the quality, character, and integrity of the individuals appointed to lead the AGC. To put matters in context, of those appointed senior counsel in the past 10 years, as of last month, only 16 were in private practice, or remained in private practice. As stated earlier, Mr. Kumar is amongst the top 6 to 7 litigators in Singapore today. He is recommended in publications such as Chambers Global and Asia Pacific Legal 500. He has been hailed as, I quote, an extremely impressive litigator. Others have observed that, again, quote, few senior counsels can rival the prowess of Hari Kumar. Senior figures in the profession have noted that he is incisive, diligent, fair-minded, possesses rare intellect, and is capable of consummate advocacy. Appointments to the public service must, of course, be based on ability, but they are also informed by a confluence of other factors, including the willingness to make sacrifices for the public good and having a heart for public service. I can tell the House that others have been approached for public sector positions, not necessarily for AGC, including some of the top 6 to 7, but they were not willing to give up their private practice for a number of reasons. Mr. Hari Kumar accepted his appointment as Deputy AG despite the considerable personal and financial cost to him. He loses the privacy he enjoyed in private practice. He also now earns significantly less than what he used to earn. We should be grateful that a person of such standing has agreed to dedicate himself to the public cause. we should welcome his spirit of public service. Second, the ultimate decider of cases is the court, not the AG. While the AG takes a position on whether to prosecute, it is the court that eventually decides on innocence or guilt. That is why, in many countries, it is perfectly acceptable for the AG to be a politician. In conclusion, we must ensure that the AGC is sufficiently staffed and led by outstanding leaders in the law. This will enable the AGC to serve as a steadfast guardian of the public interest and a steward of the rule of law.